Welcome to another legal talk here on eRadio with Hahn and Hahn attorneys and Black Friday sales. That's something we had recently. Today we're talking about how to deal with refunds and false advertising. And joining us from Hahn and Hahn is Isabella Mazzone. Isabella, how's it going?
All good, thank you. How are you, Ian?
Good, thank you. Welcome back. Nice to chat to you again.
Always good to chat to you.
So the Black Friday sale started last week and obviously has since carried on into various cyber sales. Which laws in South Africa should we consider when it comes to the issue that could arise?
So when it comes to all transactions, our be-all and end-all will always be the CPA, our Consumer Protection Act, which will always apply and assist us in these matters. But when it comes to specifically the online purchases and the electronic purchases, it's also really important to familiarize yourself with the Electronic Communications and Transactions Act, or we like to just call it ECTA.
Okay, and many people are dealing with issues where the items that they purchased online were out of stock. We saw that quite often as well. How does the Consumer Protection Act assist in this instance, Isabella?
Yeah, no, I've seen a lot of people dealing with this specific issue online and complaining about this. So the CPA actually deals with overselling and overbooking in Section 47 of the Act, where they specifically state that a supplier must not accept payment for any good or service if they have no reasonable basis to intend to supply those goods or provide those services, or if they intend to supply goods or services that are materially different from the goods or services that were accepted with payment. So there's a lot of people who've purchased TVs or whatever the case may be, and then the specific TV is out of stock, and they try to give them a different type of TV, for example. Here it's specifically dealt with. And it goes on further to say that if a supplier makes a commitment or accepts a reservation to supply goods or services on a specified date or at a specified time, and on that date and time contemplated fails because of insufficient stock or capacity to supply those goods or services, the supplier must refund to the consumer the amount paid in respect to that commitment or reservation, together with the interest at the prescribed rate from the date on which the amount was paid. So that's really, really important. And in addition, they must compensate the consumer for costs directly incidental to the supplier's breach of this contract. So when it comes to this alleged failure of actually supplying these goods, they are able to defend themselves if they have offered to supply a consumer with a comparable good or service of the relevant kind, and the consumer actually accepted the offer or they unreasonably refused the offer. So it really depends on how they deal with that issue when it arises. But it does not apply if the shortage of stock or capacity is due to the circumstances beyond the supplier's control, and if the supplier took reasonable steps to inform the consumer of the shortage of stock or lack of capacity in the specific circumstances. But they also say that due to circumstances beyond the supplier's control can be defined, and it does not mean where it results in partially, completely, directly or indirectly from a failure of the supplier in their ordinary course of business. So they can't say that it was beyond their control when actually they had slight control in it. So we must be careful that these suppliers don't take advantage of consumers who don't understand their rights. Beyond that, Section 43 of the Electronic Communication and Transactions Act also applies specifically with the online transactions. And here they specifically state that the supplier must refund all payments made by the consumer. And the supplier must utilize a payment system that is sufficiently secure in that circumstance. And should there be any damage suffered due to an insecure payment method, they would also have to be liable for any damage suffered by the consumer. So there's also been instances with fraud, but that on the case of the poor and insecure systems in place.
Okay, and is there a general right to return goods in South Africa?
So there isn't a general right to return goods in South African consumer law. A consumer cannot simply return a product because they had a change of heart. It's a general rule, and therefore some suppliers may allow consumers to simply return the goods when they have changed their minds. And in order to avoid disappointment, it's a good practice for a consumer to read a supplier's refund policy of a specific establishment before making any purchases. However, the CPA itself does allow for certain instances in which a consumer may return the goods and cancel the contract without paying any penalty.
Isabella, what does the CPA say about returning goods?
So generally, in terms of Section 20 of the CPA, there are 4 instances where you can return goods. Those instances are direct marketing, goods that have not been seen before the purchase, goods which do not meet a particular purpose, and when it comes to implied warranty of quality. So just to summarize sort of these 4 instances, direct marketing is dealt with in Section 32 of the Consumer Protection Act. And this is when goods or services which are directly marketed to a consumer, the supplier must inform the consumer in the prescribed manner and form of their right to rescind that agreement. And if a person who has been marketed any goods in that way, without requiring or arranging payment for them, those goods are then considered unsolicited goods. So if a consumer bought goods as a result of direct marketing, they have a 5-day cooling off period which applies, and the consumer may then, within those 5 days of receiving goods, return the goods for a refund. When it's goods that have not been seen before purchase, in terms of Section 20 of the CPA, if they have not had the opportunity to examine or inspect the actual goods which they received, they are entitled to inspect the goods on delivery. And if on the initial inspection they find that the goods do not meet their type or quality that they would have reasonably expected, or if the goods are made in terms of a special custom order and the goods do not reasonably conform to those specifications, then the consumer may in fact refuse delivery, receive a full refund, and the consumer can cancel without penalty. The supplier will also then have to pay the costs to return those goods. When it comes to goods that don't meet a particular purpose, we look at Section 55 of the CPA. And here they state that if a consumer informs the supplier that the goods are being bought to fulfill a particular purpose, the supplier that advises that the goods will meet this particular purpose, then 10 days after receiving the goods, the consumer can return the goods if it's not suitable for the particular purpose, and the consumer may cancel without penalty. The supplier, once again, will have to pay the costs to return those goods. It's really important to note that despite the above, the consumer is not entitled to return those goods if the regulation prohibits the return of those goods to a supplier once they've been supplied for reasons such as public health, or after having been supplied to the consumer, the goods have been partially disassembled, altered, added, or combined with other goods. And then lastly, when it comes to implied warranty of quality, Section 56 of the CPA deals with this, and it says that all goods sold to a consumer are sold with an implied warranty of quality. And this warranty gives the consumer the right to receive goods that are reasonably suitable for the purpose they are intended for, of good quality, free of defects, and in good working order, and will be durable and usable for a reasonable period of time. If goods are found not to comply with these requirements, then for up to 6 months after receiving the goods, the consumer may return the goods, have the goods replaced, or have the goods repaired by the supplier. The consumer can do any of these three things, so they can elect which one they would prefer without penalty and at the supplier's cost. However, a consumer will not be able to return the goods because it was defective or not suitable for the purpose if the consumer was made aware of these specific defects and the consumer then agreed to it or consented to receiving the goods in such a condition. Above and beyond all of those different CPA provisions, it's really, really important to keep in mind that, once again, the Electronic Communications and Transaction Act will apply to goods and services that are bought online. The ECT Act has its own consumer protection provisions, some of which will trump the CPA. Specifically, for the first three reasons I dealt with before, for returns listed above, do not apply if the ECT Act's provisions apply to that specific transaction. Instead of these rights of return, the consumer will have the right to a cooling off period in terms of Section 44 of the ECTA, which states that they are entitled to cancel without reason and without penalty any transaction related to the supply of goods or services for 7 days after delivery. However, the consumer must pay the direct costs when it comes to the return of those goods. This also doesn't apply to all online transactions, and there are, in fact, Section 42 ECTA, and I'm not going to go through all of them because obviously there are quite a few exceptions, but I really, really recommend that all consumers familiarize themselves with sections 42 to 44 of the ECTA so that they can understand how they are protected and how they are not.
Okay, and just lastly, what about false and misleading marketing when it comes to the Black Friday sale price?
Yeah, so I see a lot of people have been using all these new apps now to detect whether or not the original price actually is receiving the same discount that there's advertising on all the apps. It's quite a bit of a scam, I would say, that's going on. But I mean, obviously now consumers are woke and they figured out what's going on.
Yeah.
But firstly, it's really important to consider Section 30 of the CPA, and that actually specifically deals with bait marketing and states that a supplier must not advertise any goods or services being available at a specified price in a manner that may result in a consumer being misled or deceived in any respect relating to the actual availability of those goods or services at that advertised price. If a supplier advertises those goods or services as being available at a specified price, and the advertisement expressly states a limitation in terms of the availability of those goods from the supplier, so the supplier must make those goods available at that price to the extent of the expressed limits. It is a defense to an alleged failure if the supplier offered to supply those goods to the consumer with the same or equivalent goods within a reasonable time, and the consumer then either unreasonably refused that offer or accepted the offer, and the supplier supplied those goods. So secondly, there's also Section 41 of the CPA, which deals with false, misleading, and deceptive representations. And this is obviously the big section that applies here. And it says that in relation to the marketing of goods and services, the supplier must not, by words or conduct, so that's any type of advertising, directly or indirectly express or imply a false or misleading or deceptive representation concerning a material fact, use exaggeration as to a material fact, or fail to disclose a material fact, or fail to correct an apparent misapprehension on the part of the consumer. So there are three instances. They may also not permit or require any other person to do so on behalf of the supplier. So what is considered to be false and misleading in terms of this section? Well, this includes that any goods or services are available, can be delivered or performed within a specified time. It's when it's advertised at a specific price and an advantage exists, or a charge or proposed charge is for a specific purpose. So those are circumstances that would directly apply to these kinds of sales. So when you feel that there has been any kind of false or deceptive marketing that's taken place in terms of the CPA or any of the above that we've just discussed dealing with the CPA, the best thing to do as a consumer is to lodge a complaint with the National Consumer Commission regarding what has happened with your specific issue.
Okay, Isabella, wow, that was very interesting. That's after Black Friday, and what a Black Friday it was. I see somebody spent, I'm not sure, 400,000 or something on one of the online platforms just on Black Friday. Isn't that insane? No. I mean, what were you buying on an online platform?
I mean, what was the point of spending that amount of money? How much money you're actually saving? I mean, I think, have you seen the jokes, Eon, about girl math?
No.
I don't know if you know about girl math. Ordering enough so that you no longer have to pay for the fees for delivery and that kind of a thing. And you're technically saving money, but you're not saving money.
Exactly. But actually, I had a business report saying that the single biggest transaction that PayFast recorded this year was 627,000 Rand. A record amount for the platform, so it's even more than I thought. 627,000 Rand for one transaction.
God, I wonder what
were you buying? There. A car?
Maybe a car.
It can only be a car.
That's the only thing I would think of. Oh my word!
Goodness gracious, hey, that's hectic. Isabella, thank you so much. That was very interesting, and that's also a wrap for the two of us for 2023. Yes. Can you believe it, hey? It's at that time again.
One. Imagine that.
Yeah, so I hope you're going to have a fantastic festive season and have a great time with your family and friends.
Thank you. You too. I hope everything goes well and everyone stays safe during this festive season.
Yes, I hope so too. And then we'll chat again in 2024. Isabella, thank you so much.
Perfect. Thank you, Ian. Thank you so much for having me.
Thank you. Bye.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.